All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before for previous Ask Me Anything sessions. And for those of you who are joining us for the first time, I hope that you will make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney in New York, and I have a legal practice here in the state which focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests from both folks in the cannabis industry and otherwise. So, by all means, please send me a connection request. And you're also welcome to contact me at my email address, which you can see right here on the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions about cannabis legalization here in New York. We're going to do roughly half of the questions from a list that I've compiled from previous Ask Me Anything sessions. I've got close to 100 questions at this point, and a lot of them are fantastic. So we're certainly going to dive into the archives, as we say. And we're going to take roughly half of the questions from you, the participants today, who will be posting them in the comments. So now would be the time to post your question in the comments if you would like to ask one. I do like to always make a disclaimer before we get started with the questions. And that is, of course, that while I am indeed an attorney, I'm not your attorney, at least not yet. I will note that I do see a few of my clients in the audience today, so don't fear, folks. I am still your attorney. But for everyone else, I am not your attorney. And today's event is not legal advice. It does not create an attorney client relationship. And of course, it is not a solicitation to offer legal advice. And so, without any further ado, let's get to some of the questions. So, I want to go to a couple of questions in the backlog that were related, which makes sense to answer them together. So, we're going to do that first. And those questions together were: what is the criteria for licenses under the past conviction statute? And what about social equity applicants needing to have ownership in a business? So these are very good questions. It's clear that the question askers have an interest in either social equity being a social equity applicant. Although, since the second question referred to the ownership in a business, there does seem to be a little bit of confusion. And frankly, I have had this a lot with my clients, and when I've been talking to both existing clients and potential clients about the difference between the justice involved regulation that has been proposed by the Cannabis Control and social and economic equity applicants. So let's unpack that a little bit so that everyone can understand the difference between these items. So, as the first question went, it was, what is the criteria for licenses under the past conviction statute? And I want to make it very clear that what is being referenced here is not actually a statute. It is not something that was passed as a law by the legislature, but it is a regulation that has been proposed by the Cannabis Control Board. And specifically, that is the conditional adult use retail dispensary license here in New York. It was a proposal by the Cannabis Control Board. And the main two requirements for the individual applying under that proposed regulation is that A, the individual was convicted, and that's very important, convicted of a cannabis offense here in the state of New York prior to March 31st, 2021, when MRTA, the cannabis law here in New York, came into effect. And so, most importantly, it is a regulation, not a statute or a law that was created by the legislature. And what that means is that we need to go through a regulatory review period before that regulation can come into effect. It just so happens that the first part of that regulatory review process is a 60-day public comment window. And that public comment window actually ended yesterday. So all of the public comments are in. My guess is that the CCB got thousands of comments related to that. It was a very, very interesting regulation, which a lot of people that I spoke with were not happy with for a number of reasons. Again, the two criteria, I think I said one of them, the need of the conviction in New York. The second criteria is what I think many people were concerned about, and that is the requirement that the individual applying have evidence of owning 10% more of a business that was profitable for 2 years. So, for example, if you were a W-2 employee at a company, let's say you were an assistant manager at the busiest Starbucks in New York City, and you also had a cannabis conviction, it seems to me you would be an excellent candidate to apply for this conditional license. However, due to the fact that you would not be able to show 10% ownership in a business that was profitable for 2 years, you would not be eligible. So the important pieces of the puzzle there are those two requirements and the fact that it is a regulation or a proposed regulation, not a law or a statute. We have just completed the first phase of the regulatory review process, which was the 60-day public comment window. The Cannabis Control Board is now going to decide whether or not they want to modify the regulation based on all the feedback they got, or whether or not they just want to damn the torpedoes, full speed ahead, and go ahead and implement the regulation as it stands. If they decide that they want to modify the regulation and they do want to make germane changes to the regulation, we're going to have to wait until they make those changes. And then we will need an additional 45-day period, which is known as a revised rulemaking period. And then after that final revised rulemaking period, the regulation will be able to be promulgated, it will become effective, and the Cannabis Control Board will be able to put up the application and start taking applications for that license, very similarly to what they did recently with the conditional cultivation license. Additionally, the second question that I wanted to raise, which was similar to this, was asking, what about social equity applicants needing to have ownership in businesses? Now, again, this is a point that I've gotten a lot of confusion, both with my existing clients and people that have approached me, potential clients. So there is no ownership in a business requirement for social and economic equity applicants applying for one of the standard 9 licenses. The ownership in a business requirement is only applicable to this initial conditional retail dispensary license for justice-involved individuals, those that have been convicted of a cannabis offense, which we described earlier. For the standard licenses, any social and economic equity applicant will be able to apply for those licenses. It's the same criteria that you can find in MRTA, minority-owned businesses, women-owned businesses, service-disabled veterans, distressed farmers, and individuals from communities that have been significantly impacted by the enforcement of cannabis laws over the course of the history before cannabis became legal. So I get that that is very confusing. People tend to conflate the two, but they are definitely different. The business requirement is only, at least currently, who knows what the CCB may put in future regulation, but at this point, that owning a business requirement, and in fact it is, that business has to be profitable for 2 years, and it's a 10% minimum ownership stake. That is only a requirement for the conditional retail dispensary license that may be coming here very soon in the state. All right. Let's go to some additional questions. A few that we have that have come in today via the web. What, if any, is the criteria about fine dining with cannabis-infused food? Now, this is a very, very interesting question. And the answer to this, quite frankly, is we don't know yet. I do firmly expect that we will see something in regulation from the Cannabis Control Board. If you want to go to the Google, as I refer to it, and look up cannabis, restaurants, dining, and maybe put in Buffalo, because I believe it was a media outlet in Buffalo, or it could have been Rochester, somewhere in the western part of the state, that had a very good article about this exact issue. And they were talking to some restaurateurs that thought it would be a fantastic idea for restaurants to be able to serve either fine dining or, frankly, any kind of dining with cannabis infused food. And it does appear from that article that the folks in the OCM and the Cannabis Control Board are actively discussing this and whether or not they need to perhaps propose an additional license that would be specific to restaurants. I do think that perhaps the Department of Health would want to weigh into this because they obviously regulate all the restaurants in some capacity. But clearly, this is a very top of mind issue for folks. I would be very interested in eating at a restaurant, a fine dining, or otherwise just a normal restaurant, even a fast food restaurant that had cannabis infused food. I do think this is something the OCM and the CCB are going to think very seriously about, and as to whether or not they're going to allow it, and then whether or not they need a special type of license that they will promulgate, in addition to some of the other licenses that we've seen that were not originally in MRTA, such that these types of businesses could go forth and actually serve cannabis infused food to patrons in restaurants. So the short answer is we don't know quite yet. I encourage you to go on to the Google and look this up because there was a very good article written about it. And I do think this is something that the Cannabis Control Board and the OCM are very seriously considering. All right, let's go back to some of our backlog questions. What type of licensing is required for the logistics of product? Who will distribute cannabis when it's legalized? And interestingly enough, the answer to the question is actually contained in the question. And the answer is those individuals that get distribution licenses. So, as you may have heard me discuss in previous Ask Me Anything sessions, I like to split up the core licenses in MRTA into what I call the upstream licenses and the downstream licenses. The upstream licenses are cultivation license, the processing license, and the distribution license. And then the downstream licenses are the retail licenses, the retail dispensary, the on-site consumption, and the delivery licenses. So in the upstream tier of licenses, clearly we have the distribution license. These will be organizations that, in effect, take cannabis from processors and then distribute it to retail dispensaries and to on-site consumption lounges so that those businesses can then sell on to the public. So the distributors you may want to think of as the wholesalers. This is very similar to what you see in just about every other line of business. Alcohol business in every state is similar in some capacity. There are some very weird things about how the alcohol laws tend to work in many states, but by and large, you have some entity that is responsible for picking up the alcohol that is brewed at a brewery or at a distillery if it's liquor, and then storing and then delivering that alcohol to bars and to liquor stores or to grocery stores or other venues that will sell on the alcohol in a retail capacity to end-use consumers. Again, it is this distribution license. By and large, entities will only be able to have one distribution license. That being said, if you are a processor, you will also be able to get one distribution license of product that you process. And if you're a cultivator, you will also be able to get one processing license and one distribution license of cannabis that you grow. But the ultimate answer to the question that was asked is who is going to do all of this distribution? And again, the answer is in the question. It will be done by the businesses that have gotten a distribution license from the Cannabis Control Board and from the state. All right. Let's see how we go here. All right, another great question. How do we translate this information? And this is one of our live questions. How do we translate this information to impacted communities, particularly justice impacted? It seems as if the very communities that the social equity program were created to benefit are at a disadvantage in obtaining this information. So that's a phenomenal question, and I think there's a couple of ways that we translate it. Personally, I am trying to take an active role in going and speaking at as many events that I can about this very issue. A couple of weeks ago, I was out at the Weeksville Heritage Center, which is out in Brooklyn, and I thought we had a great audience that night. I do think we are, to a large extent, there talking about exactly the kind of community that the question asker was referring to. So I myself am going to as many opportunities like that as I can to speak to individuals that will be eligible to apply as social and economic equity applicants. I encourage all of my attorney brethren who are very familiar with the laws to do likewise. There are many of us that are very capable and competent to do this. So reach out to these organizations, to nonprofits in communities that were disproportionately impacted by cannabis enforcement, and speak at these communities. Reach out to them and let them know you have information that you want to share with these communities to help them get cannabis licenses. Additionally, something that I have spoken out quite a bit on LinkedIn about, that will significantly help in this capacity are the incubators. Now, I have written a piece on LinkedIn where I very specifically ask, where are the incubators? It says in MRTA, the law that legalized cannabis here in New York, that the state shall, that means it must do so, it's not optional, it shall stand up incubators. And the purpose of the incubators are, first, to encourage those that are eligible as social and economic equity applicants to apply. And it seems to me, if part of what you want to do is encourage people to apply, that the incubator should be up and running before the application process starts. So frankly, that means now. And second, for individuals that do eventually get a license, the incubators are supposed to provide educational programs to help those that have received licenses to learn all kinds of things about running a business, how to hire and fire, how to do inventory, how to do accounting, how to do all of the things that you're going to need to know to run your cannabis business. So I think between those of us that are well versed in the law going into communities and speaking to as many people as we can and educating them about their potential to be social and economic equity applicants, and second, the state standing up these incubators that they're required by law to do, and standing them up, particularly in communities where there are going to be many social and economic equity applicants. I think those are two excellent ways that we can go about getting this information into the hands where it's needed. All right, let's go back to a few questions from the backlog. Will the MSOs/ROs be allowed to produce and distribute to active adult use dispensaries from the opening of the market? Two things that are a little bit conflated there, MSOs and ROs. Now, MSOs are multi-state operators. Those are companies that have cannabis businesses in multiple states. And ROs are registered organizations. That is the fancy name here in New York for businesses that are participants in the medical cannabis space. And as many of you probably know, those businesses are able to be vertically integrated completely in New York, unlike the businesses other than the micro business that will get licenses under the adult use law. Those ROs are able to grow, process, distribute, and sell at retail cannabis. So let's deal with the MSOs first. The MSOs, just like anybody else, will be able to apply for an adult use cannabis license here in New York. They will be limited as to the number of licenses they get. If they are in one of the upstream licenses like cultivation, the number of licenses they will be able to get will be one, although they will be able to get a processor license and a distribution license for their own cannabis. If they're in the retail tier, they'll either be able to get 3 dispensary licenses or 3 on-site consumption licenses, but that's about it. That's the full runs the gamut of what the MSOs will be able to get. Now, that does mean that if they are a processor or a distributor, and they do get that license very early in the market as the market is opening, they absolutely will be able to distribute to dispensaries from the opening of the market. Now, looking at the ROs, I guess I should just mention real quick with the other license, with the adult use licensing, it does potentially appear that the social and economic equity applicants will get their applications perhaps reviewed first. As I have mentioned before, the number one criteria listed in MRTA, the law where it sets the criteria for who's going to get a license, the number one criteria in the law is the applicant a social and economic equity applicant. So it does seem to stand to reason that those applications may get reviewed first. But again, whenever MSOs, they certainly will be able to apply for licenses, and as soon as they get them, they will be able to cultivate, process, distribute, do whatever it is that their license allows them to do. Now let's talk about the ROs. So the ROs are fully vertically integrated, and at some point, they will indeed be able to participate in the adult use market. Now, Tremaine Wright has made it very clear in events where I have seen her speak that um, having the ROs be allowed to participate in the adult use market is not the first thing that the Cannabis Control Board is interested in making happen. In fact, she is very clear that the Cannabis Control Board has a mandate for equity in New York, and that their primary goal in the early opening of the market is going to be to make sure that the social and economic equity applicants are getting 50% of the licenses, which is the goal of the law, and that those businesses, which are going to be small businesses, are going to have an opportunity to make their way in the market, to stand up their businesses, and an opportunity to be successful before the Cannabis Control Board is going to allow very large players that are fully vertically integrated, such as the ROs, to participate in the adult use market. So, yes, at some point, the ROs are going to be able to participate in the adult use market, but it is clear from everything that Tremaine Wright has said and the mandate for the Cannabis Control Board that it is likely that that will not be at the opening of the market, and that it's entirely in the purview of the Cannabis Control Board to decide when that is going to happen. All right, let's get to another question. And I absolutely love this question, and that's why I'm going to answer it. In New York State, if you receive an adult use license, will you be able to get a delivery license as well? Although there is no vertical integration at the moment, what licenses can be combined? All right, so I think I talked a little bit about what can be combined previously. That is, if you're getting one of the upstream licenses, cultivation, uh, processing, or distribution, you can get one license that is downstream from you for your own product. So if you're a cultivator, you can get a processor and a distributor license only for your own product. If you're a processor, you can get a distributor license for your own product. And then again, over in the retail tier, although it's not really combining licenses, if you're going to get a dispensary license, you can get 3 licenses for 3 locations. If you're going to get on-site consumption, you can also get 3 licenses for 3 locations. Let's now go back to the first part of the question, because this is a great thing to bring up and it's very important to discuss it. So the delivery license is the license that has the least amount of information about it in MRTA, the law that legalized cannabis. Pretty much all we know about the delivery license at this point is, number one, you're going to be able to have 25 full-time equivalents doing delivery. For me, what that roughly means is that 25 FTE times 40 hours a week, which is FTE hours, is 1,000 hours. That tells me that as a delivery licensee, you're going to be able to have employees doing delivery for 1,000 hours a week. So you're going to probably want to have fewer delivery hours on whatever days of the week that delivery is less impactful. My guess is that'll probably be Monday and Tuesday, and that you're going to want more delivery hours on days of the week where you're going to do a lot of delivery. Again, my guess would probably be Friday and Saturday for people that want to party Friday and Saturday night. But who knows? We'll find out once delivery happens. So we know that. We know that you can only get one delivery license, and we know that the delivery licenses is one of the licenses that is to be promoted to social and economic equity applicants, along with the nursery license and the micro business license. Now, it's very interesting that in every other section of MRTA where it specifically talks about a license, it then says that if you get this license, for example, in the cultivation section, it's very clear there that it then says you cannot get any of the other licenses. It just so happens that for whatever reason, it does not say this about the delivery license. If you look in the delivery license, it does not say you can't get any of the other licenses if you get a delivery license. And similarly, it doesn't talk about the delivery license in any of the other licenses. Perhaps that is an oversight. Perhaps it's not. Perhaps it's going to be a loophole for the CCB to allow other entities to get delivery licenses. The fact is right now we just don't know. So I do expect either that to get cleaned up in later legislation or by the CCB via regulation. It's just a very interesting point that we don't know. Another very interesting point that we don't know, and I know this is not exactly what was asked in the question, but I do think it's germane to the delivery license. And that is, at this point, we do not know for certain whether or not delivery licensees will be able to do, as I call, hold their own inventory, or will they only be able to deliver orders that come in to deliver dispensary license holders. Now, it is my opinion that delivery licensees not being able to hold their own inventory will significantly devalue the delivery license. It's just clear that if they're able to hold their own inventory and take orders directly, that makes the license much more valuable. And since the delivery license is one of the licenses that it specifically says in the law, this license is to be promoted to social and economic equity applicants, it does seem to me that it would behoove the Cannabis Control Board to allow those licensees to be able to hold their inventory to give value to that license. Again, I do think the license is tremendously devalued if they can only make deliveries for dispensaries that are actually getting the order. At that point, all the delivery licensees would be able to make money on is a delivery fee, right? Whereas if they can hold their own inventory, they can make revenue the same way that a dispensary would. You would not allow the delivery licensees to have a retail store, so no one would be able to come and buy on site. But I do think this is something that the Cannabis Control Board really needs to very seriously consider. So great question. I'm glad you asked it. It's something that really needs to be cleaned up, either in further legislation or in regulation by the Cannabis Control Board, to really let us understand how the delivery license is going to work here in New York. All right, going to do one more question, and then I think we'll be done for the day. This was a great one from the backlog. I get asked this question a lot, and it's a very pertinent question because not everyone in New York is going to get a license. Yet my projection is there are going to be tens of thousands, if not over 100,000 jobs in the cannabis industry in New York State. And that includes both licensees, businesses that get licensed, as well as all of the cannabis adjacent businesses that you're going to see get started in New York. So the question there is, what kind of job do you recommend for someone getting into the industry? So there are currently ROs, the registered organizations, the medical cannabis organizations that are up and running. I would encourage you to learn how to be a bud tender, perhaps get a certificate or some other kind of training, and then go and apply and get a job at one of these ROs. Become a bud tender, perhaps become a delivery driver if you have your commercial driver's license. Look at all of the opportunities that you can get at the entry level in the existing businesses. Additionally, New Jersey now has adult use cannabis fully up and running. Maybe go across into New Jersey and get a job working for one of the adult use dispensaries over in New Jersey. There are all kinds of opportunities that are coming for entry-level employees, and getting that type of experience. Perhaps if you were a server at a restaurant, that'd be a great type of resume background to give to a dispensary to help them hire you. You do need to have, I think, a lot of knowledge about cannabis so that you can be a very good bud tender and be of service to your customers. But I do think that these types of entry level positions are excellent positions for individuals to take and learn, and then eventually apply for your own cannabis license in your own business. All right, we've hit 4:50, so I think we're going to wrap up for the day. I do want to thank everyone who's participated. Just again, we do this every Wednesday at 4:20, so please come back and join us again. If you're not currently a connection of mine on LinkedIn, please send me a connection request. I'll be happy to accept that. And as I say every week, as I know we are all very excited about legalization and the cannabis industry that we're about to have in New York, frankly, the most important thing that came out of the legislation is that we are now expunging all of the records of everyone that was convicted of cannabis offenses here in New York. They're no longer going to have to check the yes box. Have you ever been convicted of a crime when they apply for jobs or when they apply for housing? And additionally, I'm going to say something that I am working on very actively is we need to get all of the non-violent cannabis offenders out of jail. There are still people that were convicted of non-violent cannabis offenses that are still serving jail sentences. And that is unacceptable. It is unacceptable for a state to generate revenue from tax dollars doing an activity for which the state is still incarcerating people. So talk to your elected representatives, talk to your governor. We got to get everybody that was convicted of a non-violent cannabis offense out of jail. So that's my public service announcement for the week. We'll see everybody next Wednesday at 4:20. Thank you for joining us today. Everybody, have a good one.